Hi, I'm Barry Taylor from Equip for Equality, and today we're going to talk about your employment rights under the Americans with Disabilities Act. People with disabilities, including older Americans who have a physical, sensory, cognitive, or mental impairment, are covered by the Americans with Disabilities Act, also known as the ADA. The ADA covers a variety of areas, including employment. Now, which employers are covered by the ADA? The ADA covers private employers, state and local government employers, employment agencies, and labor unions. But the ADA does not cover employers with less than 15 workers. It also doesn't cover the U.S. government, but the U.S. government is covered by the Rehabilitation Act. The ADA also doesn't cover employment at private clubs and Native American tribal nations. Now remember, in order to be covered by the ADA, a person must fit within one of the following three categories. You could be a person with a physical or mental impairment that substantially limits one or more major life activities, or you can have a record of a physical or mental impairment, or you can be regarded as having a physical or mental impairment. Now, the ADA covers all aspects of employment, including interviewing, applying for a job, hiring, training, promotion, salary, termination, employee benefits, and workplace privileges. To be covered by the ADA, a person must not only be a person with a disability, but also must be qualified to perform the job with or without a reasonable accommodation. The ADA defines qualified as someone who satisfies the required skills, experience, education, and other job requirements of the job, and can perform the essential functions of the job with or without a reasonable accommodation. In certain circumstances, an employee with a disability will require an employer to make certain modifications in the workplace. Under the ADA, these modifications and adjustments are referred to as reasonable accommodations. Now, a reasonable accommodation is any change an employer makes which enables a person with a disability to either have an equal opportunity in the job application and selection process, perform the essential functions of the job, or enjoy the equal benefits and privileges of employment. What are some examples of reasonable accommodation? Well, they include modifying a work schedule, reassignment to a vacant position that the person with a disability is qualified to perform, making facilities accessible and removing barriers, providing readers and interpreters, modifying exams, training materials, or policies, providing or modifying equipment, and restructuring of non-essential job functions. An employer is required to make a reasonable accommodation unless the accommodation would be an undue hardship for the employer. Undue hardship is an accommodation that requires significant difficulty or expense, but most accommodations can be achieved with relatively little difficulty or expense. An employer may refuse to have a person in the workplace who poses a direct threat to themselves or others. Direct threat is defined as a significant risk of substantial harm that can't be reduced by a reasonable accommodation. The ADA also prohibits employers from asking disability-related questions before a conditional offer of employment. Permissible inquiries are limited to those that relate to the employee's ability to perform the essential job functions. Before making a conditional job offer, an employer may not make any medical inquiry or conduct any medical examination. However, after making a conditional job offer and before an employee starts work, an employer may make unrestricted medical inquiries, but may not refuse to hire an individual with a disability based on the results of such inquiries unless the reason for rejection is job-related. Finally, any medical examination or inquiry required of a current employee must be job-related and justified by business necessity. It's important to remember that in Illinois, people with disabilities who believe they've been discriminated against should file a charge with the Equal Employment Opportunity Commission within 300 days of the time of the discrimination. If you don't file within 300 days, unfortunately, you will lose your ADA claim. If you'd like more information about the employment provisions of the ADA, you can go to the website of the Equal Employment Opportunity Commission at eeoc.gov, or you can contact us here at Equip for Equality by calling our 800 number, 800-537-2632, or go on our website at equipforequality.org. Thank you.